Good afternoon, everyone, and welcome back to our estate planning seminar that we're having. This is our fall series of the ENT and the Area Agency on Aging Retirement Series, and we are off to a good start. This is our second in a series. We had Medicare 101 last Monday, and I'll tell you more about what's to follow at the end of our presentation today. This is our 8th season. We are so excited about it. And not only that, we have another module. We have 6 modules now, and I will let our ENT representative, Bree Shalito, tell you a little bit more about that later. My name is Pamela, and I represent the Area Agency on Aging, of course, and you probably are all familiar with us by now. But just very briefly, and I'll make it quick, we specialize in providing senior information, resources, assistance, public education, and we house the state health insurance program, fondly known as SHIP, S-H-I-P, which provides objective Medicare and health insurance information. We also are very proud of our Yellow Book, which is a senior information and resource guide we've been publishing it for at least 25 years, and we are the premier resource guide in Colorado Springs. And we also publish for Teller and Park counties as well. You will find on the website where you enrolled today, there are handouts. If they weren't there when you enrolled, they are now. And if you don't see them, I will be happy to send them to you, but we have all kinds of handouts in regards to estate planning that are there for your pleasure and your reading enjoyment. We are serving the state of Colorado, so the information we're providing for you is hopefully relative to the area in which you live. So keep that in mind. We're very excited about being able to provide that information statewide. And we're grateful for the Colorado Bar Association, the Colorado Area Agencies on Aging, and our local SHIP offices throughout the state for providing that information. Keep your microphones, if you would, off for now. And any questions that you might have, if you would put them in the chat, and our speaker will address those at the end of the meeting when we have more time to address the questions and those who might have things that come up during the presentation. It's important to make those notes for yourself. So it's at this time that I would like to introduce the illustrious Miss Bree Shalito, Senior Manager of Community Education, who will say a few words about ENT Credit Union and their partnership with the AAA. And also, Bree, if you would mention the new module that you folks are presenting, that would be great.
Absolutely. Thank you so much, Pamela. As Pamela said, my name is Bree Shalito, Senior Manager of Community Education. And as she said as well, we've partnered for 8 years on this series here to provide information to Coloradans about retirement. In prior years, many of the sessions were in person, but as with anything else, the new requirements of our world actually moved us to virtual, which has allowed us to expand throughout Colorado. So thank you for being here from wherever you are. If you aren't familiar with ENT Credit Union, we're Colorado's largest credit union. We actually just opened our 50th service center. So we're very proud to have over 50 service centers across Colorado and serve Coloradans. And our overall mission is to improve the financial quality of lives of others. This series fits perfectly into that because it's educating on retirement. We do plenty of other classes as well on all the topics you'd suggest and understand, from budgeting to credit. So if you're interested in those, take a look at our website at ent.com. But through this partnership, we've added a session that we actually present as ENT representatives from the team that's called Making the Golden Years Golden. That is a new offering that actually simulates retirement and asks you to put kind of yourself into retirement years and think about how you're going to be spending your life and also how you're going to be spending your money. So really looking forward to that one, and looking forward as always to Skip's presentation on estate planning. And I'll give it back to you, Pamela. Thank you so much.
Okay, thank you, Bree. Appreciate that. We're honored again to have with us this year, as I mentioned earlier, our prestigious Skip Morgan, attorney at law for Morgan Law Offices, PC. He specializes in wills, trusts, estate planning, probate litigation, protective proceedings, and military law. I hope I got them all, Skip. So please join us in welcoming Skip Morgan. and save your questions if you would, put them in the chat and we will address them at the end of the presentation. Please welcome you, Skip. Thank you.
I don't know. I have trouble with distinguished, illustrious, or any of those things too. I can understand why you choked on that.
Oh, come on now.
And you always forget my Nobel Prize.
Oh, yes.
Now, how you can do that in physics?
Sorry. I'm going to make a note about that one.
Speaking of Nobel Prize, I was recently on vacation and I was down fishing in the Caribbean and I ran into an engineer classmate of mine from the academy. And, I told him, I said, I'm here because my house burned down and everything I owned was destroyed by the fire. And the insurance company paid for everything. And my friend said, that's quite a coincidence. He said, I'm here because my house and all my belongings were destroyed by a flood. And my insurance company also paid for everything. I looked at him for a minute and says, how in the hell do you start a flood? Anyway. I'm here because I have kind of a passion for taking care of the elderly. I do protective proceedings, guardianships, and conservatorships. And unfortunately, times of tragedy in a family can bring out the best in people and it can bring out the worst in people. And my objective in doing estate planning and even in doing these seminars is to anticipate trouble and head it off and make sure that when tragedy happens, and it happens to all of us, it happens to all of our families, that families will come together and not to blows. So speaking of Caribbean fishing, that's a lawyer going after the last dollar. So I'm going to give you what I refer to as 4 tickets to a lawyer-free retirement. There are a lot of seminars that you pay money for or you don't pay money for, and you get a bad filet mignon and people want to sell you something. I've always thought it would be the ultimate of ironies if there were to be like a dental seminar and they would have free taffy or something like that for you. And if somebody stood in front of the group and said, you know what? Everybody needs a root canal. Everybody does, sooner or later. You may not know it out there, but you need a root canal. And it just so happens that we have a dentist outside in the lobby. And after you're done, normally root canals are $2,500 and he's doing them today for $1,200 each. Nobody would pay any serious attention to something that silly. And yet, unfortunately, people tend to do that when it comes to legal preparation and legal documents, assuming that one size fits all. Well, each one of us is different. Each one of our families is different. Our values are different. What we have in our estates are different. And that requires that you pay particular individualized attention to your situation and make things work to your benefit. So the first ticket is to make a will and keep it up to date. Why do you do that? First, you want the smooth transfer of property to the people that you want to have your property. So that's always, of course, important. Not having a will means that your property is not necessarily going to go to whom you want it to or in the proportions that you want it to. And who are the wrong people if you want it to go to the right people? Well, if we were live and everything, I say, okay, I want some nominations for who are the people that you don't want to have your life estate. And okay, that was a local probate bar meeting. One is the tax collector. All of us want to minimize taxes. And in particular, we know that death and taxes are inevitable, as Ben Franklin said, but they don't have to necessarily be simultaneous. And I think as we proceed here, I will be giving you what for many of you will be very good news with respect to taxes these days. And yeah, most of us don't want to have lawyers taking a large chunk of our estate either. And there are ways, and I'm going to tell you what those ways are, to make sure that lawyers don't take the lion's share or even a large share of your estate. And then my third group of people are what I refer to as assorted crumb bums who are not on your Christmas card list. And many of you, just as I said that, are probably picturing just who those people might be. So the first principle of estate planning is to leave no ambiguity. Colorado has a really nifty law that says you don't have to have a will that specifies where every oil painting, every firearm, every antique buffet is going to go, because you would constantly be having to redo your will. So what Colorado law allows you to do is to have something called a tangible personal property memorandum. And what that is in your will, you will say words to the effect of, I intend to leave my tangible personal property in accordance with a memorandum that I'm going to prepare. And by just saying that, you can have such a memorandum, and it doesn't have to be in the will. And it doesn't have to be notarized. And it doesn't have to be witnessed. It can be on a yellow piece of legal pad if that's what you want. And why is that important? I'll tell you why. Kids will fight over the darndest things. I had a case years gone by of a family where they had been quite frugal and had invested wisely. And when the couple passed away close to each other, as is oftentimes the case with senior married couples, and they had $3 million. And they had 3 kids. So the division is not particularly difficult, not even for a lawyer. But they also had a lot of stuff. He was Russian in extraction, and so they had a lot of Russian triptychs and souvenirs, mementos. And those kids fought over those things because for years and years there had been this sibling rivalry, there had been jealousies and so forth that had just sort of smoldered and simmered under the surface. And when mom and dad died, and they probably spent $15,000, $20,000 in attorney's fees fighting over the smallest little artifact, like nested dolls, for example. And it simply made no sense. And that's because there wasn't a personal property memorandum. I had a pair of brothers who actually spent about $30,000 fighting over Mattel Hot Wheels. So it's strange what they'll fight over. And you don't want your personal representative, and typically for most of us, one of our senior children will become the personal representative. That's the same as the executor. And you don't want that child to have to referee Family Feud over a Hot Wheel, particularly if the personal representative is interested in a Hot Wheel. When mom and dad die, and particularly when they die close together, stuff can suddenly become a whole lot more important than it ever was before. And things that you think are unimportant suddenly become important because it's a piece of mom. And, you know, mom touched this. This was mom's favorite vase or what have you. And when they fight over those, there's no room for grief. And you can actually have kids who otherwise were getting along fine suddenly become estranged over tragedy. And that can be avoided with a personal property memorandum. It's also a way to keep heirlooms in the family. For example, A couple may have, or the wife may have some very valuable jewelry that may have been handed down from her great grandmother. So it's something on the female side of the family, and the couple may have no girls. Well, this is the way that you can keep things like that and give it to somebody maybe outside the immediate family that you want to have something. It's a great way to keep heirlooms in the family and not just on auction. So, personal property memorandum, take advantage of it. Colorado makes it easy to do. I wanted to go back. I had a case where an elderly woman who was suffering a little bit from dementia, and she had 3 or 4 kids, and she had a lot of very nice stuff. She had works of art. She had beautiful antique furniture pieces, and we decided that it was important for her to identify to whom these things would go. And so one evening, we went around and the kids were there, and she had different colored Post-it notes, yellow sticky and pink sticky and blue sticky, and that was assigned to each one of the kids. And she went all through the house and had all those Post-it notes staked out there so that the kids would know what was who went and who got what. And then the next morning she woke up, looked around, said, "What the hell are all these notes doing?" all over the house, and tore them all down. So a good way for a couple to do this is when the next time comes along, when you're together with the family at Thanksgiving dinner or what have you, go ahead and ask, is there anything in particular that mom and dad have that is important to you and that you would like to see? And you can head off a lot of trouble. Okay, second part of a will is the importance of harmonizing your probate and non-probate assets. Now, this can get confusing, but here's the way to remember it. Joint tenancies, beneficiary designations, where you say, okay, I want a payable on death, IRAs, 401ks, all of those things pass outside of probate. They are not counted as a probate asset. They go immediately to whoever you have designated as the beneficiary. But what's important to remember is that if you have a will and you maybe have 3 children and you want to make sure that each of them participates equally, whatever that child gets from a beneficiary designation or an account that's payable on death does not, repeat, not count against his or her 1/3 share in our hypothetical where there's 3 children. Now, there's some things like IRAs and 401ks that can only be passed by beneficiary designation. But the important thing is, if you want your estate to transfer in roughly equal portion to all 3 kids or to whoever your beneficiaries are, you want to make sure that your non-probate assets are divided equally, just like your probate. Very, very important. And I have had, sadly, a number of occasions where we put together a very carefully constructed will to make sure that, say, the 3 children are treated equally. And then mom or dad start opening up accounts and they get some very helpful advice from the clerk who says, you know what, if you put these things in payable on death and transfer on death and joint tenancy, it won't go through probate. And as a result, their entire estate plan is just turned on its head, and they might as well not have done it in the first place. So very important. And whenever you have a clerk who helpfully suggests that you make something payable on death or transfer on death to, quote, avoid probate, Tell them the agreement that I have with all banks, and that is that I promise not to do any banking if they promise not to practice any law. Because in Colorado, as it turns out, probate is the fastest and the easiest and the least expensive in the country, bar none. It's better to pass assets through probate than not. Okay, I was going to mention a little bit about taxes and say that I've got, very good news for you. In years gone by, the federal estate tax has recently, if you want to call it that, is 2000, 2001. An estate could be up to about $1 million before it became taxable. Well, particularly as property values, your home and residence, as their values went up, suddenly a whole lot of estates were subject to federal estate tax. As of today, as I speak, the applicable exclusion amount, that is to say, the size of the estate that you have to have before there is any federal estate tax, is over $12 million a person. So that's substantial. And that means that a married couple is going to have over $24 million. I dare say there is nobody that I'm talking to right now that needs to worry about that. And if you do need to worry about that, please call me right away when this is over. So most of us don't have to worry about the estate tax. Now, it will default back to, I think, $10 million into 2026. But again, for most of us, that's not a big deal. That means, and this is important, that gifting, which was once a very useful tax avoidance plan, you could gift so much money every year to as many people as you wanted. And I think the latest number was $14,000 or $15,000. And people would do that to reduce their estates below the applicable exclusion amount. That's obviously no longer necessary for nearly all of us. So gifting has no tax advantage to it whatsoever. The federal estate tax is portable, and that means the married couple have a cumulative $24.12 million estate before it becomes taxable. Well, what about Colorado inheritance tax? So we can take the feds off the table when you're worried about taxes. Colorado used to have what was called a siphoning tax, where there was a maximum federal estate tax credit for state inheritance tax. Now, because nearly nobody has an federal estate tax, and because there is now no longer a Colorado or any state inheritance tax credit, Colorado has no state inheritance or transfer tax. That is not true of all states. A number of states do have it. New Hampshire comes to mind. New Hampshire has, some of you may remember, they have a license plate that says, New Hampshire, live free or die. And there's some truth to that because New Hampshire does not have a state income tax. However, New Hampshire does have a fairly steep inheritance tax of its own. So my feeling is, truth in advertising on license plates, it ought to say, New Hampshire, live free, but if you're starting to feel chest pains, head for Colorado. I've said that the state tax is dead, and for the time being, that is true. However, in the FY 2023 presidential budget, there is talk of doing things that will reinstate that tax. For example, reducing the applicable exclusion amount to $5 million is one of the suggestions in the act. And the other one gets really bad, and that is to get rid of the capital gains tax on appreciated assets. And again, I don't really want to get down into the weeds on this, but it's enough to know that today, the way the law is, when mom or dad dies, even though they only paid $30,000 for their 4-3 rancher house, it's now worth $500,000. There is no capital gains. You get a step up in basis to the value at the date of death. And that can be a really big advantage. I have clients, for example, who have Summit County ski property, and they bought it back in the 60s for, like $55,000, and today it's worth $750,000. As long as they don't give that to anybody before they pass away, there will be no estate, or there will be no capital gains tax on it. But one of the suggestions is to eliminate that exclusion. I also want to talk a little bit about the importance of a will as an instrument of reconciliation and not retribution. And this is important. Bearing in mind that my objective, and I think most of our objectives when we do estate planning, is to leave no reason for hostility and conflict in your estate plan. And that means that the testament part of the will is often overlooked. For example, funeral, burial arrangements, organ donations. It used to be that when you died, your body was no different than a carton full of books. I mean, it was considered chattel, and your personal representative could do whatever he or she wanted to with it. Now, you can include with your will or your advanced planning documents, funeral, burial arrangements, organ donations, and all of that is enforceable as a matter of law. So that can become very important. Children can fight over whether there's going to be a cremation, whether there's going to be a service, and so forth. And so I urge all of you who are doing your estate planning to have that discussion with each other and with your children as to exactly what you want. Doesn't necessarily have to be committed to writing, but for heaven's sakes, make sure that people know. And then another thing to do is a recreational property trust. And I really like these. Going back to, my clients who have Summit County, a Breckenridge property, and I have some others who have like a ranch in Westcliff and so forth. And the idea is you want your children, your grandchildren, your family, and so forth to continue to enjoy that piece of property and not just sell it off and divide the proceeds. Well, that's the thing that you can do. You can actually put into your will a recreational property trust, or actually I usually create them beforehand, into which you donate that property and make it available for a long time, a couple of 3 generations if you want, for a recreational property trust for your family. And that's a nifty thing to do. And it's a legacy that's, I think, more permanent. In that case that I told you about, where you have $3 million and you divide it 3. So that's what's left to mom and dad. Everybody takes a check and that's it. Whereas creating something which is lasting, a legacy for children and grandchildren and maybe great-grandchildren that you've never even seen, is something that is a good part of estate planning. And it's something that you want to consider if you're in that situation. Also important is special needs trust. Some of you may have a special needs child or grandchild or what have you, and you know that if they are receiving Medicaid assistance, that if they get money out of a will or a trust or what have you, that it will disqualify them for Medicaid. There are, however, something called special needs trusts. They are a creature of statute. They have to be worded just so, but it enables you to leave a sum of money for a special needs child or beneficiary that will not disqualify them for public assistance. And again, you want to see a competent estate planning attorney knows how to do that, but it is something to be sure to put in to your estate plan if you have a beneficiary that the gift that you want to give them might actually disqualify them from benefits. Also important to handle blended families fairly. I grew up in the Air Force and spent 34 years there and retired. And I did I did legal assistance like other JAGs did. But one of the things that's always is a conundrum is you want to be sure that in a blended family situation, that is to say, there are children from husband and from wife, from previous marriages or relationships. And your will says everything to my wife or husband if she survives me. And then if not, then to the children in equal shares. That is a common sort of a way of handling your estate plan. But that doesn't work very well for a blended family because that means that the children of the first to die may miss out altogether on their parents' bequest. So you want to make sure that blended families are handled fairly, and there's a way to do that to guarantee that it doesn't matter in terms of who ultimately ends up with the estate. It's divided equally no matter who dies first. A no will means this. First, that the state law decides who is going to get your estate. Had a number of cases where there has been a divorce in the course of somebody's life, and they end up strangely owning a house, the marital residence, as tenants in common. And unlike what you might think, as a tenant in common, each of them owns a 1/2 interest in the residence, and upon the death of one, the ex continues to hold half of the title. So you want to be very careful to make sure that state law doesn't make sure that one of those crumb bums that I told you about ends up getting your estate. I've actually had a case where stepchildren end up being co-tenants with a surviving spouse. Never a good situation. Okay, there is a legal presumption that a spouse will be a principal, but not necessarily exclusive heir. In Colorado, when you can disinherit anyone you want, you don't have to have any child or children take under your will, except you cannot disinherit a spouse. There is depending upon how long the marriage has been, a spouse is entitled to up to half of the gross estate. And if you don't give half to that spouse, they can do something called an elective share and family allowances and exempt property allowances. And that means that the spouse will take the lion's share of the estate, even if that was not the plan. And again, there's a way to fix that, because you can have both spouse, particularly maybe in blended marriages, there can be a postnup or a prenup that agrees that they will not elect against each other's will. And of course, personal property memorandum is not enforceable unless it's part of your will. That is to say, it's mentioned. And the state decides who gets minor children. You get to nominate the guardian of minor children. And for many of us, we want to set up a trust for them because the idea of a teenager suddenly taking several $100,000 worth of money should make most of us sit up in our chairs or in our beds at night, the sheets soaked with sweat, screaming. And you don't want the state to decide not only who gets your children, but when they take your inheritance. And remember, once again, non-probate beneficiary designations always, repeat, always trump the will. And then you want to decide who's going to become the personal representative. And I'm going to discuss that in a few minutes. But deciding who should be your alternate personal representative is an extremely important decision. And it can sort of be the linchpin about how well the administration of your estate goes. And probate administration is almost always more expensive if you have a will. And I know the general feeling is, well, gosh, I don't have an estate. I think that, estate, we think of Jeff Bezos or, rich people have estates, but all of us have something, and it is always easier, faster, and less expensive to have a will than to not have one. What about a trust? In many states, and I'm going to use California as an example, attorneys who administer the probate of an estate take a percentage of that estate. And that means the larger the probate estate, the more the attorneys take home. Believe it or not, in California, where else, not only do lawyers take a percentage of the estate, but the law prescribes that they are entitled to it. So as you see down there in the bottom, the probate attorneys get 4% of the first $100,000. Well, that's $4,000 right there for a very small estate. You get up to $1 million and lawyers are taking a lot of money. In Colorado, that's not the case. Most of us, and I'm not going to say all because I know some do, but I don't charge a percentage of the probate estate. So I charge for how much work I do based upon the hours that I put into it. And typically I ask to probate an estate for a $2,000 retainer, and frequently I end up giving some of it back because I don't earn it all. And most people do that. So building a trust to avoid probate is not, it's not a thing in Colorado. In fact, the other way around. In Colorado, probate involves nothing more than taking the original will to the El Paso County Probate Registrar, filing 4 documents right here from my computer, and within a week to 10 days it's probated. You don't have to go to court, no testimony in front of a judge, no affidavits, none of that. That's how easy it is. I can usually get a will probated before even a death certificate is produced. The other thing that they sell you about trust is, well, it's private. Not necessarily. If somebody wants to contest the trust, just like if they want to contest the will, it's going to be in court, it's going to be public. But informal probate in Colorado means the will is not public. So it's no more or less private when you do a trust. And do you save money? No. Trust, for the most part, in Colorado will cost you more than probate. There are, however, a few reasons to have a living trust in Colorado. And these are them. One is if you have out-of-state real estate. Most states are very jealous about the dirt, which is located inside of their borders. And so when somebody passes away, say here in Colorado, but they have property in Wyoming, such as a case that I have now, you have to go into Wyoming and basically open up another probate in that state. And it may not be nearly as friendly and as easy and as inexpensive as Colorado is. So I sometimes tell people who have out-of-state real estate to put that real estate in trust so they don't have to go through probate in that. A second really good reason and this is a substantial portion of my practice, is what are called protective proceedings. And protective proceedings are meant to take care of somebody who may be losing capacity, dementia, Alzheimer's, and so forth. And when I have a couple that approach me and one of them is starting to suffer from Alzheimer's significantly, I want to set up a trust right away to make sure that there's continuity of care, so that if something happens to the able spouse, there will not be kind of this vacuum into which predators will insert themselves. Ticket number 2, the general durable springing power of attorney. Death, as it were, is easy in terms of the legal work that needs to be done, typically in Colorado, but incapacity, not so much. Let me move back into protective proceedings. If somebody loses capacity to manage her affairs to the point where she's not able to balance a checkbook, pay the bills, anything like that, and again, predators move in. If there is no power of attorney, then you have to go to court and you have to get a conservator appointed for that person. A conservator is a court-appointed fiduciary who will then take over managing the money for the protected person. A general durable springing power of attorney prevents that from having to happen. And what do I mean by general durable springing power of attorney? At the common law, a power of attorney, somebody that you gave your power of attorney to, had no more capacity than the principal. So in sort of a paradox, if the principal lost capacity through dementia, the agent wouldn't have capacity either. So durable means that the power of attorney survives your incapacity. Springing means it only comes into effect at your incapacity when you need it. Before we went to Vietnam, everybody went through this processing line, and you had to basically do a general power of attorney. Most of us did, with our spouses. But unfortunately, back then, because it was not springing, guys came back to find they'd been divorced in absentia with the power of attorney. So springing says it only comes into effect at my incapacity. And that way you don't have two potential legal use involved. That is an important thing to do for long-term care planning, because unfortunately, if somebody suffers a stroke and they no longer have capacity, suddenly they need to go into potentially assisted living, temporarily or otherwise, and there's nobody to contract for them that has the authority to contract for them. Power of attorney steps in to take care of that. It's also important that if, and I'm going to get to guardians in a minute, but a guardian conservator needs to be appointed, you can specify who you want those people to do and not leave yourself to the mercy of the court. So disability planning. For example, it sometimes becomes necessary when one or the other of the spouses goes into skilled care, memory care, or what have you, that it no longer makes sense to have the house and so you downsize. But typically the disabled spouse is a joint tenant. So with the power of attorney, you can sell, transfer, or lease the real estate without having to go to court. It's good for tax filing. And it's good for Medicaid planning. It's a little bit too detailed for me to go into today, but Medicaid planning is an important component of estate planning. For some of us, we may not have the kind of resources that will enable us to be in long-term care. And bearing in mind that Medicare does not pay for long-term care, which is what we're calling nursing homes these days. It doesn't pay for that. So you either pay for it yourself, or if you are indigent, then Medicaid will step in. Again, Medicaid is it's kind of a complex way of looking at things, but there is a way to, if Medicaid is potentially at issue, to do planning in your power of attorney that will enable you to take care of Medicaid by doing what are called Miller Income Trust and purchases of community spouse annuities. And of course, contracting for long-term care. You want somebody to be able to step in and do that for you, because you may not be in a position to make a good decision yourself. Downsizing and selling a family home, another good thing to have a general power of attorney to handle. So in a nutshell, the general durable springing power of attorney is about your money. It's about you're no longer being able to handle your money and somebody being able to step in without having to go to court. And along the lines, we've been talking about nursing homes here for a minute or two. Some of you may have had the experience of putting a loved one or a family member into a nursing home, long-term care, and you are suddenly approached by somebody who says, you know, there's a benefit you may not know about that is, you know, worth up to $2,000 a month, and it's tax-free, and you can keep Medicaid, and you can shelter your assets from creditors and state. Well, it's what they're referring to as Veterans Aid and Attendance Compensation. It is an extremely complicated benefit. But what typically these people are doing is trying to talk you into an irrevocable trust where you hide all of your assets from the Veterans Administration. And that way you get this so-called up to $2,000 a month. It is a high front-end load IRREV trust that they produce. They take a substantial portion, then they sell all of your assets, they put it into this irrevocable trust, and then put it into front-end load annuities. So this is one of those things where if it sounds too good to be true, almost always it is. That's not to say that Veterans Aid and Attendance is not appropriate for some of us. It is to say that this dude right here is not the guy you should be buying it from. If aid and attendance is an issue, for heaven's sakes, go to an attorney who knows what it's all about, and so that you don't end up damaging your loved one's financial future. Because when you give away this money into an irrevocable trust, you've just disqualified yourself from Medicaid for 5 years. And that's not something they tell you about. Ticket 3, the medical durable power of attorney. That is kind of the reciprocal, the other side of the same coin as the general durable springing power of attorney, but it's obviously about medical. This appoints an agent for medical decisions when you're no longer, or temporarily or otherwise, able to make decisions for yourself. Now, this is very important. It may sound strange, but I've had situations where married couples who've been together for 40 years, and he's in an automobile accident, and she rushes down to Penrose, Maine, and says, you know, how's my darling husband? And they won't even tell her that her darling husband is there unless she has a medical power of attorney. Never mind that they've been married that long. So it's vitally important that you have this thing in place, because particularly in medical situations, time matters. So in the hypothetical we're talking about, if she has a power of attorney and the surgeon says, look, we don't need authority to save his life, but his pelvis has been smashed and we need to do some surgery to try to repair that. And we need somebody to give us legal authority to do that. Having a medical durable power of attorney is priceless. It's also priceless for end-of-life planning, and I'm going to talk about that in a couple of minutes. But end-of-life planning is just what the name implies. You have your own set of values, what's important to you, what you want doctors to do and what you don't want doctors to do in the last days of your life. And you want to be able to make sure that those wishes are understood and they're respected. It's also good for disability and long-term care planning to have a medical power of attorney. The more the person who has your medical power of attorney knows about it, the better chance you stand of having your wishes honored, even when you're not in a position to advocate for yourself. And of course, there's the perils of HIPAA. Had a situation where a woman been married a very long time to her husband, but she was suffering from dementia, and she wandered away one night, and they looked everywhere, and he was calling the hospitals and everything to find out where she'd gone, if they could locate her, and the hospitals wouldn't talk to him because he didn't have a power of attorney. And unfortunately, she finally was picked up by a medical care facility down near Southgate, and they asked her, said, who should we contact? Are you married? And she said, no, I'm not married. She'd been married for over 50 years. Okay, you can avoid a court-ordered guardianship. That's the same thing, or the reciprocal of the conservatorship. If you don't have a medical power of attorney, and if you are disabled to the point where you're no longer able to make medical decisions for yourself, then there's court is going to appoint a guardian, and that may or may not be the person that you want. Protective proceedings can be expensive. They are inherently adversarial. You will have to go to court. Your family certainly will. And they can be divisive because unless you've picked who you want to be, have your medical power of attorney, you can have kids and other relatives fight over who should be controlling your life. And that can be disastrous, unpleasant, and expensive. Remember this, you are the boss of you until you're not. So it doesn't matter what a piece of paper says, you make decisions for yourself. And if that time comes when you're not able to, then you want to make sure that the person you select is the one who's there to advocate for you. And the living will, which is an advanced medical directive, is sort of a subcomponent of the medical power of attorney. And it is dealing strictly with end-of-life decisions. Now, I think many of us, if we don't say this ourselves, we've kind of heard, well, if I'm going to be paralyzed, if I'm going to be blind, if, I pull the plug. I don't want to live. I will tell you, in 44 years of experience, I have never seen a person actually in that situation who said that. The will to life is strong. It truly is. And I've never met, and I have met and known and represented quadriplegics who said, I'd just rather be dead. So the advanced medical directive is important because it tells your doctors what you want them to do and what you don't want them to do. And let me just kind of give an example about what mine says. Kind of 4 criteria. If I am unconscious, in a coma, or otherwise unable to make or communicate my decisions. 1, 2, I suffer from a terminal disease or condition from which there is no reasonable medical expectation of my recovery. 3, my physician and one other physician certify the first 2 in writing. And 4, I have been in this circumstance for 7 days or longer. Then, and the then portion is not pull the plug. In fact, that's kind of a misnomer. Typically, what happens is that if you are in extremis like that, you're going to be given nourishment and hydration. that is to say, food and water, intravenously or otherwise. And pull the plug means withdraw that. So it means, practically speaking and medically speaking, you're going to die of dehydration and not the underlying disease process, whatever that might be. Yes, it also includes dialysis, ventilators, heart-lung machine, and so forth. It is not a do not resuscitate order, not a do not resuscitate order. The way I build mine is that I don't want doctors who have an inherent conflict of interest, if you will, because you're using resources, to be able to pull the plug, so to speak, without looping back into your family and your loved ones and the people that you know and trust and love you and respect you and your decisions and your values. So what I say is that before they can do that, after 7 days, they need to go to your medical power of attorney and get that medical power of attorney's permission in writing. And I'll tell you a real world practical case that actually happened with one of my living wills. Elderly woman suffered a massive stroke, and I mean a stroke that actually just laid her flat and put her into a coma. And 7 days came and went, and she was in a coma. And so the doctors could not do it themselves. They were ready to pull the plug, but they had to go to the power of attorney, which happened to be this woman's daughter and her adult daughter. And the doctors told her, you know, your mom's living will says 7 days, and it's been 7 days and she's still in a coma. And daughter said, well, last night I was talking with mom, as I was for every night since the stroke happened. And I was stroking her arm and just talking to her. And she squeezed my hand. She squeezed my hand. She hasn't done that before. Let's wait a little longer. Maybe mom's going to come out of this. Well, mom did come out of this. And I don't mean this twilight, hazy kind of an existence or anything like that. She fully recovered her faculties and lived for another 1.5 years to enjoy her children and her grandchildren. So the living will is a very important thing, but remember, you're the boss of you until you're no longer able to. And then, by golly, you probably want somebody that loves you and knows you and appreciates your values to be the one making that call. And that complements, it does not supplement the medical power of attorney. We have here in Colorado something called the medical order for scope of treatment. Most form, it's a green form, it's on the bed. That potentially is a do not resuscitate order. It can supplement your living will, but it doesn't replace it. Appointing fiduciaries, and I'll try to go through this relatively quickly, but you have a lot of fiduciaries. You've got your personal representative for your will. You've got who you appoint as your power of attorney, your medical power of attorney, and your financial power of attorney. You've got trustees that you may appoint, and guardians and conservators and attorneys, in fact, and yes, lawyers. And the question is, who you pick. So I'll often have couples will say, well, I'm not sure about who ought to be my fiduciary because each other is going to be our personal representative. But which one of the kids do you think I should pick? We got, Joey's a lawyer and Susie's an accountant, and this is my recommendation when you're trying to decide who it is. One, it's the person that not only you trust, but that your kids trust. And two, it's the one that gets along better, the best. The one, maybe it's the only type B in the whole family. I've got 5 kids, 8 grandkids, and I've got 4 of the most driven type A personalities in the world. the youngest, is so laid back, and he's a type B. And that's who I picked. That's who I picked because he is trusted and gets along with everybody. Special expertise, accountant, lawyer, doctor or nurse or something for the medical power of attorney is not as important as that sense of trust. You have this idea, okay, there I am, face up on the gurney at Memorial Hospital. Who do I want looking down and making decisions for me? Okay, the ticket 4.5 is a smart book. All of these documents that you would prepare an estate plan are meaningless unless somebody knows where they are. That very fast administrative probate system that I've been telling you about only works with the original will. If the original will can't be located, Colorado assumes that the testator intended to destroy it and or revoke it. So you want to have your will in a place where it's not going to be consumed along with you in the same fire, and where, of course, each other knows where it is, and where, and if you're single, where your personal representative, alternate personal representative, knows where it is. It's fine to put it in a safety deposit box. Just make sure that your personal representatives and your fiduciaries know that it's in there and that they have access to it, a key or whatever is necessary to get into it. So these documents need to be in the hands of the people that you've appointed, your personal representative and your powers of attorney. Another what if nobody knows about a disabled spouse? And there's some very, very sad stories that I've experienced, unfortunately, about this sort of thing. But it is often the case these days that when one of the other spouses is starting to suffer from dementia, and truthfully, often as not, it is the female. They seem to be more prone to it or more vulnerable to it. And so the able spouse takes care and makes sure that appointments are met, make sure that telephone is answered, make sure that meals are prepared, that transportation is provided. And sometimes these couples have been living alone for a long time, and their adult kids have no idea that mom is suffering. That has led to some very tragic situations they're really heartbreaking, where the able spouse suffers from a stroke and is taken away by the EMTs, and they find mom face down 3 days later. Nobody knew that she was utterly dependent upon him for her support. If you have that situation, it may be embarrassing, but it is vital that your family knows it, so that if something does happen to one, somebody is there to step in. You want somebody to have your user IDs and passwords. Now, that sounds strange, but if somebody needs to look and pay off the bills, know about your bank accounts, CDs, all of that sort of thing, more and more of us are banking online. If they don't have user IDs and passwords, they are helpless. You might as well not have the power of attorney. So some of us get some of those password apps, the gist of which is that you have one master, really complicated password. And then once you access that, it will give you the other ones for whether your Social Security or your pharmacy or what have you. That's one way to do it. If you don't want to do it that way, you want to make sure that your powers of attorney and your personal representative have user IDs and passwords, and you keep them up to date. Give that medical power of attorney and that living will to your primary care physician, so that he or she knows who to contact in the event that something happens. And again, if you put stuff in the safety deposit box, make sure that your fiduciaries know that that stuff is there. Also, keep a listing of your life insurance policies. It is not the case that life insurance broker is reading the obituaries and sees Morgan. Oh yeah, we got $1 million policy on him. Let's call his widow up and tell her this is her lucky day. Doesn't work that way. So you need to make sure that your family knows, or your fiduciaries know, what policies you have, whether they're paid up, what the proceeds are, and who the broker is that they are to contact if something happens. Bonus tip: ask questions while the price is right. And if you do have a question, probably the easiest way to do it is with the chat.
Okay. I don't see any questions in the chat, but I have a couple of questions that can get us going. If there's nobody who has a burning desire, this is your opportunity, folks, as his little cartoon says. Bonus tip: ask questions while the price is right. Well, I'm going to go ahead and ask a couple questions. So what happens, are your relatives responsible for any debt that you have?
Short answer, no.
Okay.
They are not. Now, that doesn't mean that there isn't responsibility. People, if you carry a credit card balance, there will be a claimant against your estate to pay off that credit card. Obviously, in the case of mortgages, they are secured by the property itself. So a mortgage is going to have to be paid, possibly when the property is sold. But the short answer is you are not responsible for the debts of a family member unless you were responsible before they died. That is to say, it was a joint debt or it was a joint account.
Okay. All right, I have a question here. I was told just yesterday by my financial advisor in Denver that it was $9,000 to probate a will in Colorado, ?
False. Totally, unequivocally, and indisputably false. As I said earlier, I charge usually a retainer of $2,000, and usually that's just about right. So once again, I promise not to give you financial advice if they promise not to give you legal advice.
Okay. Is a will and or a trust better with an estate worth under 1 million?
No difference. A will is better in Colorado because it's less expensive and it is faster, and it administers just as well. There is no relative advantage to a will or a trust with respect to the size of the estate until you get up to the $25 million estates where the federal estate tax starts to come into play. And then there are some things that you can do. But for 99.44, 100% of us, a will or a trust doesn't save you anything.
Okay. We have another one here. Do you have recommendations for a single person?
Well, and I apologize. I kind of go into this thing with the traditional family in mind, but I do have single clients, and one of the things for them that I think is important is maybe they're charitably inclined, and to give serious consideration to charities or churches or movements or so forth that you believe in. This is an opportunity to put your money where your values are. Because for a single person, the way Colorado and most states' laws are, laws of intestacy, if you die without a will, as a single person, I kind of liken it to crossing yourself. And that is, your children will take, if you have any first, then your parents, if they are surviving, will take. And if you have neither surviving children or parents, it goes laterally to your siblings in equal shares. And if you don't have any parents or children or siblings, they will find some degree of relation. You may have a great niece or nephew that will take. I had a situation like that recently where there was a couple, this is a relatively substantial estate, and neither one of them had children, parents, or siblings. Luckily, they did have a will, and they did want to give to charities. Now, as to a single person on fiduciaries, who do you trust? Doesn't have to be mom or dad or anybody, but who do you trust?
Skip, aren't there actual fiduciaries as a business that you can actually have a contract with them? I mean,
Yes, you can expect to pay a good deal of money.
Okay. All right. Can you have?
Bree, what if a child moves in as a caregiver? Do they have any additional rights in a will? Wait a minute, you're going too fast for me here.
I was going to ask you a question, and then
I was just reading. Yeah.
Can you have two personal representatives?
I don't recommend it.
Okay.
The reason I don't recommend it is this. Because sometimes people say, well, I've got two children or what have you, and I don't want to hurt somebody's feelings. And it shouldn't be that way. This is a matter of not loving somebody more or anything else. As I said, the number one criteria for me is who gets along best. But I always tell them, if you do two, then you've just doubled the paperwork. You've made everything harder. And if one of them is, as they usually are in Zimbabwe, and the other one is climbing, K2 in Tibet, it can be really cumbersome to try to get the estate administered. You can have, I want one, and then if that one is not available, then somebody else. That's a better way to do it, because you don't want to have to do every real estate transaction with two signatures on everything. So can you? Yes, I don't recommend it.
Okay. What happens if your attorney dies before you do, and he is the only one in his business?
Only one what?
And he is the only one in his business.
Oh, I could die tomorrow and none of my clients would miss me, because any competent attorney can give you the same guidance as this. So attorneys, it used to be the attorneys actually kept wills and that sort of thing. Nobody does that anymore. For that reason. You want to have continuity. You don't want to be worried about what happens if my lawyer dies or gets disbarred or both.
So if that happens, then where do you go?
You find out who does probate.
Oh, okay.
I mean, I'm not saying that the internet is there. It happens that in El Paso County, probably some of the most prominent names are not necessarily who I would pick. But that's a good point in the question. You shop for your lawyers. Don't just take the first one you see on the internet. Find somebody who is really interested in doing a service to you, where you matter, where you're not just treated like you're an assembly line, where you see a clerk and everything, and you give them all the names of your brothers and sisters and great grandnephews, and the computer spits out an estate plan. And that's a matter of trust.
Right. Okay, here's another question. What if a child moves in as a caregiver? Do they have any additional rights in addition to a will that does the 50-50 designations between two children? Would you like me to read that again, or?
Nope, the answer is no.
Okay.
Now, that doesn't mean that when a child moves in as a caregiver, that arrangements can't be made for compensation, for offset, and so forth. But the law does not give them any more rights.
Okay. A question here, a living will or a will, what's the difference?
The will is just what the name implies. The will is, I, Chester Morgan, being of sound mind, and so hereby declare this to be my last will and testament. Everything to my wife if she survives me, and then to my children, and so forth. The living will is the end of life instructions to your doctors. So, completely different thing. It's an advanced healthcare directive.
Okay. Our next question. I have moved to Colorado from Georgia. I have a will, a medical POA, and a living will. Do I need to rewrite it for Colorado?
I would have to see them. My answer is probably not. But if anything has changed since moving here to Colorado, and for example, if your Georgia estate plan has a living trust, you may not want to keep that in Colorado because it can be cumbersome. So it's one of those things where I can't say categorically one way or the other. But if your question is, will a Georgia will be honored in Colorado? The answer is yes.
What about the opposite, Skip? What about someone who's got a will and everything set up here in Colorado and they move to another state like Tennessee?
Like Tennessee or like California or someplace, if they move to a state where attorneys take a percentage of the probate estate to administer the estate and to do probate, then it's time to revisit, and then a living trust might make a whole lot of sense and save a whole lot of money. Colorado is kind of unique in how fast and easy our probate is.
So basically they should find a lawyer and find out what is needed.
Right. I mean, you go to another state, you want to say, get a good, and word of mouth is one of the best ways, who do you trust, and say, what do you think? Is this still going to be appropriate? And that lawyer will be able to tell you one way or the other. And I see that all the time. And often as not, I'll say, well, I'm talking myself out of a job, but there's really no reason for you to spend money to change this. It'll work just fine.
Okay. Any other questions, folks? Did you say at one point, Skip, that the personal property memorandum was not enforceable?
No, it's not enforceable unless you mention it in your will. You have to have this little paragraph that says, I intend to have a personal property memorandum. If you don't have that paragraph in your will, it's not enforceable.
Okay. And is it true that someone, you've written out your directives in terms of your medical power of attorney and so on, and when it comes down to the final analysis, and the loved one or the executor or the person in charge knows what they need to do, but they just can't do does their will then have first priority over the deceased?
And that's a good question. And that's one of those things that you put into your thinking when you're doing this planning. It is a terribly hard decision, I will grant you. But I think nearly all of us would rather have a family member make that decision, or a trusted friend, than the doctors who don't know you.
So what you're saying is then they would have, what their decision is could possibly be different than the deceased.
No, that's the reason for the living will. The living will and the medical power of attorney, when I do them, have the same language. So the criteria have to be met. Unconscious or in a coma. Terminal disease. 2 doctors certify, 7 days or longer.
Okay. All righty. Folks, we've got a few minutes left for other questions. Did you have your contact information somewhere?
I think it's on the title. I think it's on the title page.
Okay. If you all need further information on that, you can, or you need other information as far as the handouts or anything, you can send it, you can email this office, you can email me at phogard@ppacg.org. All right, well, folks, thank you for hanging in there. Bree, did you want to make any last minute comments before we get ready to close this presentation?
As always, just want to thank you, Skip, for your time and the lessons and the tickets that you've provided us tonight. Many great questions. So really appreciate all of you for joining us and asking these questions and getting this information. And as always, Skip, providing it for free of cost. This is very important information that we all can use to better our financial future. So thank you so much.
You're welcome.
We have the next Monday is Jane Barton, who is presenting a presentation called Retire by Design. And then the next 3 sessions will begin on September 12th because we have a holiday in there on the 5th. So we'll be, after Jane's presentation, we'll start again on that following Monday. They are all at 4 o'clock. And I welcome everybody to attend. And thank you. There will be a survey sent out. We would like you to fill it out and send it back to us if you would be so kind. It's very short and very sweet. Thank you again for attending, folks. And hopefully we will see you next week.